HMRC have the ability to issue formal information notices of various different flavours. These may be issued following a failure to respond to an initial formal inquiry, or may be received by a taxpayer without any such prior notice. Information notices generally may be issued in the following forms. Firstly, a taxpayer notice. Secondly, a third party notice. And more recently, the introduction of financial institution notices. Clearly, HMRC's ability to inquire into a person's tax return would be fettered if they did not have corresponding powers to require a taxpayer to provide information to enable them to check a return. One such information power is the ability to issue a taxpayer with a taxpayer notice, and under such a notice, the taxpayer must provide any information that is reasonably required for checking his or her tax position. The power is very broadly drawn, and there is a limited power of appeal. Secondly, HMRC also have the ability to issue so-called third-party notices. Prior to the Finance Act 2021, HMRC could only obtain information from third parties by issuing one of these third-party notices. Such a notice requires the relevant third party to hand over information reasonably required to check that person's tax position. Importantly, such a notice may only be issued if firstly either the taxpayer agrees, or secondly the first tier tax tribunal approves the notice. Such a notice will usually be issued where HMRC is seeking information for their own inquiries into a taxpayer. However, in some rarer cases, it might be issued where an overseas revenue authority is conducting an investigation into a taxpayer. Thirdly, a financial institution notice, or FIN, busted the third-party notice safeguards I've just referred to. The legislation introduced by Finance Act 2021 allows the Revenue to issue a FIN requesting information about a financial institution's customers for the purposes of domestic or overseas tax investigations. As the notice can be issued without HMRC first having to obtain approval of the FTT or taxpayer, we see that an important safeguard has been removed from the taxpayer. The issue of a FIN must be approved by an authorised HMRC officer, but that's not really much of a safeguard. The applicable test is whether the information requested is, in the reasonable opinion of a HMRC officer giving the notice, a kind that it would not be onerous for the financial institution to provide or produce. FINs may only be issued to a financial institution and not to any other third party. The taxpayer will receive a copy of the FIN and a summary of reasons why the information is required. It should be noted that the FTT can decide that that requirement is waived as well. There is no appeal against a FIN, and as such the only way to challenge the issue of such a notice would be via judicial review, and that is going to be beyond most people, of course. The usual restrictions that apply to a Schedule 36 information notice will also apply to FINs. For example, a person is only required to produce something that is within his or her possession or power. So if you receive any kind of information notice from HMRC, then you should act immediately. Please let us know if you require any assistance in dealing with its contents.